Ich freue mich, dass wir heute gleich 2 Gäste haben, plus 2. Also das heißt, hier steht Anna Tarnowska mit den dunklen Haaren, mit den blonden Haaren, Agnieszka Bień-Kacała. Und das sind 2 Spitze, 2 pommersche Spitze namens Kokos und Sid. Also wir sind gut verstärkt in bester Gesellschaft. Und ich stelle den Lebenslauf der Hunde nicht vor, das müsste Agnieszka später noch tun, sondern ich stelle die beiden vor, die sich hier mit Verfassungsrecht und Verfassungsgeschichte sehr gut auskennen. Anna Tarnowska haben wir schon mehrfach erlebt, also ich habe sie mehrfach erlebt. Wir waren auch mit einer Gruppe von Studenten zum Blogseminar, Studentinnen in Toruń im letzten November zum Nationalfeiertag und haben dort sehr interessante Sachen unter anderem zur Rechts- und Verfassungsgeschichte herausgefunden. Anna Tarnowska kommt aus Toruń oder lebt in Toruń. Sie ist Rechtshistorikerin, Professorin an der Nikolai-Kopernikus-Universität Toruń, an der Fakultät für Recht und Verwaltung, in der Abteilung für die Geschichte des rechtlichen und politischen Denkens und das deutsche Recht an dieser Universität. Sie hat 2007 oder wurde 2007 promoviert, 2020 habilitiert. Daraus sind Publikationen hervorgegangen, von denen ich am Ende zumindest ein paar nennen werde. Sie war Fellow an den verschiedensten Orten in Deutschland, aber auch in Italien, Belgien und zuletzt in Indien. Sie war Mitglied der internationalen Forschungsgruppe The Rise of Modern Constitutionalism, in dessen Rahmen sie den Quellenband Polish Constitutional Documents 1790, 1790 to 1848 herausgegeben hat, 2008. Und sie war auch beteiligt an der polnischen Sektion des Projekts Rechtskulturen des modernen Osteuropa unter Federführung des Max-Planck-Instituts für europäische Rechtsgeschichte in Frankfurt am Main und hat dort einen Schwerpunkt auf polnischer Verwaltungsgerichtsbarkeit gehabt. Zuletzt war sie Mitglied des ERC-Grant Reconfort, Reconsidering Constitutional Formation, Constitutional Communication by Drafting, Practice and Interpretation in the 18th and 19th Century Europe, geleitet von Ulrike Müßig in Passau. Ihre Forschungsschwerpunkte, die kann man sich schon fast ableiten, ist die Geschichte des Rechts und des Staatsaufbaus, Verwaltungsgeschichte und Verfassungsgeschichte in vergleichender Perspektive und insbesondere das öffentliche Recht in Preußen bzw. Deutschland im 19. und 20. Jahrhundert, das öffentliche Recht der Polnischen Republik der Zwischenkriegszeit, Gender und Recht, polnisches Verfassungsrecht und Rechtsstaatlichkeit in der Gegenwart. Und das bringt die beiden hier zusammen. Zu den Publikationen von Anna Tarnowska ganz kurz eine Monographie, weil XY Pole ist, Prusko niemieckie państwo prawa wobec polskiej mniejszości 1850 do 1914 roku, Toruń 2019. Und der besagte Band, oder nein, das ist ein wichtiger Aufsatz, Dualismus der Verwaltungsgerichtsbarkeit der Zweiten Republik Polen, Justiz im Spiegel der preußischen und österreichischen Einflüsse. Das ist eigentlich ein seltener Zugang, weil diese preußisch-österreichische Zeit in der Regel nicht so stark berücksichtigt wird. Das ist ein Aufsatz in Justiz und Justizverwaltung, erschienen 2013. Und dann hat sie eben aus dem Reconfort-Projekt aus der Forschungsgruppe Rise of Modern Constitutionalism mit Horst Dippel herausgegeben, Polskie Dokumente Konstytucyjne oder Englisch Polish Constitutional Documents 1790 to 1848, in München 2008 erschienen. So, und ihre Partnerin, die hier nicht von der Uni Toruń kommt, beziehungsweise sie war mal an der Uni Toruń, habe ich nachgelesen, also Professor Agnieszka Bień-Kacała von der Universität Szczecin. Sie ist Professorin für öffentliches Recht, also nicht Rechtsgeschichte, sondern öffentliches Recht an dieser Universität. Sie hat 2004 promoviert mit einer Dissertation zum Prinzip der Steuerhoheit in der Verfassung von 1997, hat sich dann 2013 habilitiert zu den Quellen des öffentlichen Rechts in der polnischen Verfassung von 1997 und war dann von 2015 bis 2022 eben Professorin für öffentliches Recht an der UMK Toruń und ist seit 2022 an der Uni in Szczecin. Sie war auch 2019 bis 2023 Mitglied der Beratergruppe zur Kontrolle der Verfassungsmäßigkeit des Rechts beim Senatsmarschall der Polnischen Republik, also auch eine öffentliche Tätigkeit. Ihre Forschungsschwerpunkte überschneiden sich mit denen von Anna. Einmal das polnische Verfassungsrecht und der Verfassungsvergleich, liberaler und illiberaler Konstitutionalismus, der Schutz der Menschenrechte und die rechtliche Ungleichheit oder auch Gleichheit von Frau und Mann. Publikationen: Konstytucjonalizm nieliberalny w Polsce po 2015 roku, bei Beck in Warschau 2024 erschienen, mit Timea Trinoshi herausgegeben. The transition from liberal to illiberal constitutionalism in Poland and Hungary, the language of rights and equality, in einem Sammelband herausgekommen. Far-Right Newspeak and the Future of Liberal Democracy, erschienen in London, New York 2024. Und dann schließlich zur Gegenwart, fast Gegenwart, Abortion and the Electoral Campaign in Poland, Anno Domini 2023, erschienen in Przegląd Konstytucyjny 2024, also das Recht auf Abtreibung. Es gibt einige gemeinsame Publikationen, ich nenne jetzt nur eine. Power of Authority, a few words about the Chief of State 100 years ago and the present. Also das heißt, was verbindet, ist sozusagen das gegenwärtige und das vergangene Recht und ansonsten die Gemeinsamkeit Verfassung und Gender, würde ich sagen, hauptsächlich Verfassung, öffentliches Recht. Bin gespannt, was ihr mitgebracht habt. Wir haben hier schon den Titel stehen, den muss ich nicht nochmal wiederholen. Also, das habe ich. Das ist vielleicht.
Also vielen Dank. So, vielen Dank für die nette Vorstellung. Leider werden wir heute Englisch sprechen. Ja, verzeihen Sie uns bitte für besonders mir, für alle Sprachfehler. Leider, das ist so, dass manchmal und besonders bei solchen Zentren geht es nicht so smoothly, but we'll try our best. So, Agnieszka, share the invitation, the very nice invitation from Yvonne. So we are so happy, so proud to be here and to share some ideas of us to present you the project, which is financially supported by the National Science Center of Poland. So this is the main institution. We have the huge 4 years project entitled Does the Assembly Law Matters? Analysis of the evolution of the freedom of assembly in Poland. And we would like to show you some ideas about what the project is planned to be. This is the still very first year of the realization. We are heading the main period of work. So only some introductory remarks. We were dealing with some theoretical framework, with constitutional framework. The main idea, of course, and this point, the most important point is, of course, mechanics of the assembly. So how it is going from the law through the administrative bodies to the people on the street. How does it work, or is it working or not, in which fields? And what we finally are trying to find, and that will be the end of our presentation, is this link between the freedom of assembly and the quality of democracy. How to establish it, how to grant it, and it would be something that we'll be telling you something from today. Okay?
Yes, this is my turn. Thank you very much for having me here, and my dogs, the dogs. So, and sorry for them, but I hope that you don't mind. So as for theoretical framework, it is the task of our friend who is doing this project with us. What we would like to emphasize here, that thinkers like Tocqueville, Habermas, and also Lassalle. We will not talk about these things, but what is important for us today is real constitutions versus the piece of paper. So we would like to show whether we have real constitutions and it is, oh, sorry, it is reflected in practice, or practice is disconnected from the constitutional provisions. Yes, as for our scope of research considers Polish constitutions, the freedom of assembly in Polish constitutions, which are two interwar period constitutions of 1921, 1935, and after the Second World War, within the socialist or communist period, we have constitution of 1952, and after the transition, we will speak about the constitution of 1997. What is important to show you that the part of the constitution, this communist constitution, after the transition that took place in 1989, some provisions were also into force until the Constitution of 1997, and it is connected mainly with the human rights. So, firstly, the freedom of assembly was regulated by the provisions of Constitution, Communist Constitution, but it was reinterpreted by the Constitutional Tribunal within the period until 1997. Also, we can say that our constitution with actual validity and that they were real constitutions, one of the interwar period and this currently binding constitution. As for the constitution of 1935, this constitution was autocratic and freedom of assembly was not reflected at all in this constitution. Yes, and constitution of 1952, it was like, well, the piece of paper, we could say, yes, because the practice and reality, political reality, was not connected with what actually should mean for the people, the constitution, what should mean. Here, yes, we have, I will not read for you those articles, but here they are described how the constitutions reflected on the freedoms. Also, we would like to emphasize that we have some laws on assembly. They were separate laws on assembly connected to the only one subject, and they are not. They are not connected with the year of the constitution, because you can see here the law on assemblies from 1932. So it is not like the constitution of 1921. Previously, we had partitioners' law in the particular parts of Poland, and then unification of the legislation. After Second World War, we also have the separate assembly law. As I said, firstly, the law was the practice should draw on this legislation, but it was not, because everybody thought that this law was a compromise. So the very first statutes after the transition was enacted the new legislation on new law on assemblies. Then we have the law on assemblies of 2015 that reflects the constitutional tribunal developments on that. And what is especially important, because also 2015 is the year when illiberalization of constitutionalism started, but it was this law is I would say liberal law. But after this moment when the governmental majority changed, then we have December 2016 and amendment to this law, introducing recurring assembly. We call them cyclical.
Yes, expressive parties. Thank you, Agnieszka. So we are already in the 21st century, so that was quick. We didn't decide to go a purely chronological way. We rather decided to go only by some interesting topics. And let me introduce some of them we identified for today's lecture. First, for example, we will try to take a look on material scope of the freedom. So the question is, what exactly for this legislator in this all periods is public assembly? Did they try to define it in any way? Are there any exemptions, for example, concerning religious ceremonies? Because this relation between state and religions are important also to define the political regime. So, for example, election assemblies. Today, for example, there is a separate category in Polish law, which is mass events. For example, concerts, music concerts, sport competitions. So assembly law is rather for the political thing, for some worldview issues, and this is what it is used for. This idea of the separate administrative law is purely German, I would say. That is the German tradition, Prussian tradition, to have the separate law, and it's for all German länder. They have also the laws on assemblies. I once took a short look at this. So this is the German. It is not so common in the world, because sometimes it's enough to have this freedom of assembly in the constitution, and then, for example, only some criminal provisions. But we have this very detailed procedure, which is developing during this decades, as you can see. We also take a look at the method of legalization. So if I would like to organize legally the assembly, what should I do? And one important thing is here to notice, to underline, this is this fundamental trend towards democratization, because in the early laws, it was always like there is a formal requirement of permission. So you have to wait till the authority will say, okay, you can go with your assembly. Now we have this notification model, which is also strongly supported by the European Court of Human Rights. And the basis is, for example, to inform the authority that we would like to organize assembly in this term and this date with probably so many people, and this is enough. And now the role is up to authority. What would they do? Do they allow it, or do they prohibit it? How will they organize police, for example, for this day to secure the people attending the assembly? So the German law, of course, was all about permission, formal permission, and since 1990, only notification is sufficient, and it's really very, very easy at the moment to legalize it. Another question is organizers and participants. Are there any exclusions based on age or gender or nationality? Generally, no. Of course, we expect that every citizen, not only citizen, everyone, for example, as it is stated in our constitution, could attend any assembly. But there was the problem with the age, for example, and of course we have some limitation who can formally organize assembly, because it has to be a person with the legal capacity to be able to bear the responsibility if something will go wrong. So the minors can't be organizers of the assembly. And we have here this provision of Verein Gesetz. It's not crossing, this is this unifying German regulation. And this was this first one when ladies could also attend political assembly. So it was the huge change in Germany. And of course, it was adopted then in this part of Poland, which was former German district after reborn Poland in 1980. Another question to ask is, okay, so on which grounds can the assembly be prohibited? So legal grounds, legal premises. And we also will say something, because what is law is boring, especially by this weather, and we will try to skip it possibly quick way and to come to the practice, and practice is much more interesting, I think. But let us tell something about the law, just to show you later, okay, where's the problem with our research. And in this late part of our presentation, we also will say something about, for example, problems with the constitutional state of emergency, and some critical things on the prohibition of the assembly in this area. And of course, generally, what we also take a look at is the protection of the freedom of assembly. So we are trying to establish what is the role of administration and the courts. Do they really fulfill their duties? Do they really support? Do they really grant this freedom? And for example, European Court of Human Rights emphasized that citizens must have, for example, a real opportunity to appeal against the prohibition within a reasonable time. For example, court can help to organize it. And this is exactly the practice of Polish assemblies in the last 2 decades at least. So if we would take a look on Act of 1932, for example, in this law, assemblies were divided into indoor and outdoor assemblies, so demonstrations, marches, some other activities outside, they were called assemblies, and did not apply. This law did not apply to, for example, so these obvious exemptions in the law were, for example, religious gatherings, processions, weddings, funerals, pilgrimages, social gatherings, family gatherings. So that was really long list. What is taken out of this law? We saw very quick change after the Second World War. So the communist authorities, of course, they were more into control of the religious ceremonies, and religious ceremonies outside churches became subject to the assembly law, and the permission was required. The exemption was Corpus Christi procession. So this is a Catholic procession taken every year in June. And that was the only one which was generally allowed by the communist authorities, but the route had to be agreed with the authorities. And for years, it was the one of the largest processions of formally non-political nature during the communist time period that was monitored till the late 80s. Really. So there were always policemen in the crowd, and they were just listening what our people are talking about. So I think that's maybe quite similar to some other countries of our bloc. In the Act of 1962, what is important, I would say that privileged organizers. So, for example, assemblies organized by socialized economic entities, social organizations, youth formal organizations, they were always privileged. They didn't have to require this permission. They always need only to notify. When parallelly, the ordinary citizen had to require always this formal approval for eventual assembly. And of course, I think that you have some idea how could it look in the communist time. So the huge assemblies are to formally support the communist government, the Communist Party. We will also show some pictures from the 1st May parade, this biggest communist parade in many countries of the Eastern Bloc. 1990.
Yes, 1990, the Act of 1990. We see the new regulations connected with the definition of assembly, and we have the gathering of 15 people. We are not sure why it was put in the statute, but we think that it is connected with the communist practice that considered conventions between
Conversations between
several people as an illegal. That was a freedom to meet under this number. Yes, after when the meeting was bigger, then the protection was granted to such of assemblies. We have also listed some restrictions in the legislation. Also, we have the kinds of some listed gatherings that were not granted or recognized as assemblies. We have official meetings, and also what is important here, this Catholic Church was directly introduced to the legislation, and activities of Catholic Church are excluded from the act. Also, what is important here, that we have some like high parks, when the local municipalities could designate places where the organization of gatherings did not require notification. So they were easy to access and to gather there. As for Act of 2015, you can notice that there is no the number of people that are required to recognize the meeting as an assembly. It is connected with the Constitutional Tribunal decision. Spontaneous assemblies were introduced, and the protection of such spontaneous assemblies was granted. And also we have the provision that excluded some kinds of meetings from this legislation. So they are like public authorities, the same, and you can also see here that it is like churches, and Catholic Church is not emphasized. So we see the change in the attitudes from the authorities or legislator, that the Catholic Church should be placed on the same level as other churches and religious associations and not emphasized. And general restrictions, they are not in the statute because Constitution lists them. And in 2016, as I said, part of liberalization of the system, we have cyclical or recurring assemblies. Why they were introduced to the legislation? It is connected with so-called Smolensk monthly ceremonies, or we even name them as montenaries. We invented this word, like miesięcznice. Rocznica is for a year, and miesięcznica is for every month. So in English, there is no, such word does not exist, so it is also not our projection, so we say montenaries. And yeah, they were meant to give protection to this kind of gatherings organized by Law and Justice, by Peace Party and Jarosław Kaczyński, who wanted to emphasize the death of his brother, but obviously it was described as also connected with all victims of the presidential plane crash in 2010. And they are privileged, yes, on the many grounds. We will tell about that later.
And these montenaries, they are still taking place. So it's 15 years after the crash, and every month they meet, the political circles of this party, Law and Justice, and they meet and contribute, and so it's something valid because they use this.
But the protection is not granted
anymore.
Yes, after the 2023 election. Yes, so In practice, these montenaries were not listed as cyclical assemblies, but what we have as a cyclical assemblies, they are not many, and we can, list here like religious gatherings, for example, rosaries against abortion. This is very popular. And commemoration of the founding of the Solidarity Trade Union, which is understandable because it should be even connected with some great events in Polish history. So this is such a kind of event. And also we have Independence March, and we faced like a lot of proceedings connected to recognize the Independence March to be a cyclical assemblies, but it is not as far as I remember.
So this is what you have seen, I think, with a group of students in Warsaw. That's a specific event very much connected with the right wing and far right wing.
Yes.
So organization are the organizations of this Independence March, and many different political profiles celebrate this anniversary of the independence in other way in other cities also, not in Warsaw, because it is dominated by this right wing. So
yeah, we have some summary that about the definitions that there were attempts to define as assemblies, but some of them were abandoned. Like for example, this 15 people. The communist law, yes, it was granted. This law granted some protection to special kind of organizations, and also the control of the Catholic Church, and churches were. How to say, like we're not among those privileged organizers. And as I said about this Catholic Church, then only in this legislation were emphasized and further not.
thank you. Thank you. So shortly about legalization, I already mentioned this main and the most important change. So from this procedure to obtain the permission to only notify, and since 1990 we have this procedure, this very simplified procedure that you have no later than 3 days before the date of the assembly, you should just inform the authority that you would like to organize the assembly. It could be done even by email at the moment, so it's very easy. Where you can just inform. There are plenty opportunities how to inform the authority, and it only requires some details: who is the organizer, some details about how many people, what roles, and it's the end of the story, really. So it's very simplified procedure at the moment, and it was supported by the case law of European Court of Human Rights, as I said before, and also Polish Constitutional Tribunal. When we take a look at organizers and participants in different acts, in different statutes, it's always the same about the legal capacity. So the adult citizens of Poland, armed people may not participate, only, for example, of course, enforcement, law enforcement, as police and any other kind of officers. And representative of the authorities has always the right to dissolve the assembly. And it's still today this idea, someone has to monitor, for example, and if the assembly breaks the rule, breaks the purpose, breaks some criminal rules, it can be dissolved and the attendance should disappear. The language of the proceedings must be indicated if it is not the official language. So in the German legislation, it was like only German, or maybe some minority languages, but they have to, for example, to be more than 60% of Kreis, so the small districts. And in Polish, it was like, if it is not Polish language which will be used during the assembly. You have just to notify what language would it be, just to allow the authorities to send people who know the language to be able to monitor it. Told many things about this communist law, and we also underlined the fact that professionals and social organizations were the privileged organizers, which only needed the notification, and always the same repetitive condition: armed people may not participate in the gatherings of all kinds. In 1990, again, organizers are people with the full legal capacity, legal entirety, so the organizations may be organizers of the assembly. And again, persons in possession of weapons, explosives, and other dangerous tools are prohibited from participating. This is something what we agree, okay, this is objective condition. We have this some of the requirements have we constitutionalized. Everyone, not only Polish citizens, everyone shall have the freedom to organize peaceful assemblies and participate in them. But the Constitutional Tribunal ruled that, okay, it must be only the full capacity, legal capacity person, so an adult, not the minors. Again, this condition about weapons, explosives, pyrotechnic devices, and other dangerous materials or tools, they again may not participate in assemblies. Agnieszka, would you like to say?
Yes. I'm sorry for them. They are asking questions and arguing with us. So as for recurring assemblies and privilege that is connected with them, you may see that it is the competence to give the status of recurring assembly is granted to provincial authority and not local authority, which is connected with this provincial authority is connected with the government. It is governmental official. So it is very controversial, and it was controversial because of this illiberal government. Now we can say that our government is maybe not purely liberal, but more liberal. And now I think, Ania, you can correct me, that there is not a problem of such recurring assemblies. They are not popular.
Yeah.
So they were previously and not now.
But the whole idea is breaking these fundamental rules. For example, first come, first served. So generally there was full equality. If you would like to organize the assembly, you have to be first in this place to notice the authority as the first, and that was your place, your spot. But with the cyclical, that was problematic because they just dominated the other rooms.
Yeah, and this provincial authority may dissolve other or ban other regular or ordinary assemblies when such an status is granted, like this recurring assemblies. So summarizing, we see that the legal capacity is emphasized everywhere in every regulation, and also that people only without weapons can participate in assemblies because they are peaceful assemblies. So it is connected also with that. And Ania would like to say some words
so
about
the picture is not from Poland. You can't see this picture in Poland because, of course, it is not allowed to carry the weapon in the public places, and not especially in assemblies. It is, of course, the United States. So they really are allowed to have weapons during the assemblies, gatherings, also in public buildings, what you may notice, for example, during the protests against some COVID restrictions. So it was very popular. You could really take such pictures like this one. Okay, when we take a look on the legal grounds to prohibit, it's always contrary to the provision of the arts, the treat and safety, peace and public order. The only thing which I would like to emphasize is the public interest in this communist law. Public interest is, I would say, very arbitrary category, and you can just understand everything as public interest if you are the authority. So that was something different. It is always about public safety and order, and for example, looking at the contemporary provisions, there is a threat to human life and health or to property on a significant scale. So this is this objective condition. This is the reason why the authority can ban this proposed assembly. We would like to say something finally about the practice and some pictures from different times. And let me say something about the interwar practice. That was a violent period. Really, sometimes we don't recognize it. We don't understand how violent it was. And we are talking about the Poland which was newly reborn with so many legal problems. Generally poor, initially weak state, marked by many political and economic crises. So especially the latter was a particular cause for protest with industrial strikes and demonstrations against unemployment. There was an amazing book of three researchers, Cichoracki, Anna Duchrat, and Mierzwa, who distinguished, for example, the protest against duties and modernizations, for example, against agricultural reforms, against taxes, other kind of rural strikes, and the other categorization in this book is against a political backdrop, and these are protests by the legal opposition or some subversive moments, especially instigated by the Communist Party, and also at the far right, so nationalist ground, I would say. I will mention only two of huge waves of riots which started maybe formally legal and then it just broke up. So for example, Krakow riots, called also Krakow uprising in November 1923, that was in our poster, some pictures from these events, and that was connected purely with economic reasons, delays in wage payments, hyperinflation, shortages of such fundamental goods like meat, flour, or coal. And Socialist Party, some trade unions proclaimed a general strike, announcing it on the 5th of November, but the clashes broke out on the streets on the very first day, and during the night, the authorities decided to impose a total ban on gatherings, even in buildings. Police blockades were set up, but these were broken by the workers. Some funny stories also was happening there. And this was the way as protesters faced some of the weapons and even armored vehicles were sent into the crowds and bloody crashes broke out. There were really many fatalities, and finally people of Krakow began to support the protesters and the army withdrew. The event led even to the fall of the prime minister, Vincent Vito's government. So it was the reason to fall the government, really, these events in Krakow. So some information from very popular magazine, Ilustrowany Kurier Codzienny, and every day new information were on the first pages, what is happening there and what's happened there. The other, and it is called the Great Farmers' Strike, are the events from August 1937. And again, it was, at the beginning, it was about the economy, about the difficult economic situation, but it grew in something different, in very, I would say, pro-democratic protests. So police called some of the organizers even terrorists. And it also turned with many fatalities among police officers and protesters, especially in Małopolska, Podkarpacie. And it was the difficult time. It was after the coup d'etat of the late 20s. That was difficult situation. It was more authoritarian state at that point. The former prime minister, which I just mentioned, Vincent Vitos, was forced into exile. And the protesters were really suppressed very brutally. There were mass arrests, even 5,000 people were taken. Some villages were even destroyed, which were very involved to a high degree to the protests. One of the authors, one journalist, even called it the largest mass social protest in Poland until August 1980. and also some pictures from that. We also try, of course, and this would be also the main part of our job, is to research archives. And I will took for you today a small cases from our Woiwodschaft. It's Pomerania district, not far from Toruń. It's Tuchola. It was in German. It was called Tuchel. And some samples, just who were the organizers of the assemblies at this area. For example, independence activist group, some agricultural societies, also organizers of the harvest festivals, and also German minority is visible here in this area. But it was the area with the strong influence of national democracy. So this is the right wing. And weak influence of the Polish Socialist Party. And it was for us a surprise. So especially my colleague is dealing with the subject, and he told us it's completely lack of balance, because we expected, okay, some of the assemblies will be organized by socialists, some by these nationalists, but it was not the case. It was right wing who is absolutely dominating this area. The assemblies were political in nature, devoted to the criticism of the government, and sometimes also very openly anti-Semitic overtones. So it's just, you can see some letters, some leaflets from these assemblies, and that was really very surprising and tragic, I would say, for us to see this atmosphere which was on this place. And for example, that was the application. Some of independence activists would like to organize assembly, and the competent authority told them, okay, you can organize it, but what we need is to supplement the exact road of the demonstration. We need also the list of the speaker. We need the topics, what they will talk about. And finally, there was also we found also the protocol. Some police attended this meeting and told yesterday to the authorities, okay, they were talking about this and this and this, and they talked also about the politics, but that was distinctly separationist nature. And as we mentioned, the Poland was reborn from these three parts. And the huge aim, of course, was to unify it. But they were still thinking about, okay, we would like to stay, for example, with our German laws, not to be unified in many different legal fields, for example. So that was mentioned, that was observed in this police report to Starosta. There was also, for example, application from the Association German Union, and the answer from the authority was, okay, we prohibit the public gathering outside, but we gave you permission to hold meeting on the premises, so in the building. In the building you can meet, there will be not so many attendants this way, so you can meet, not on the open eyes, not in the public. In these times,
yes, thank you. So as for the practice of communist times, you may remember this mass gatherings in support of communist state. But what is interesting here, that the large protests, mass demonstrations and strikes take place outside of the legal regulations, and they are illegal. They are not granted any permits, and they could be pacified by security forces. These are, of course, these pictures show you this march of the first the Labor Day. And yeah, this was our reality. Yeah, but we don't have this mass protest pictures, and they were really violently pacified. So as for this period of after democratic transition, I said that the new law had to be enacted, but what is also important here, that first protest after the transition was connected with, or they went against neoliberal economic policies, the price increases, credit costs, and layoffs. So workers and farmers demonstrated their opinion on that. Apart from this labor and economic issues, we can distinguish also the ideological issues that people demonstrate against the liberalization or restriction of abortion law. We had also the first tolerance march in Krakow in 24. And then we have, after the 2015, this illiberal turn, we have the political issues that are important for people who want to protest. For example, connected with the so-called like deform, which is not reform, but the opposite of the Supreme Court.
And also local courts, and the picture is from Toruń, because even in smaller cities there were protests, huge protests against this law, new law on the courts organization and the judges' status.
Yes, some assemblies, because of the topic, were controversial. So we have equality parades or nationalist assemblies, and also this independence march on 11th of November, as we said, and they were also rather banned or restricted by local authorities. However, according to courts jurisprudence, they were allowed because it is not possible to ban or restrict assembly a priori. So it should be some elements that are actual and they are justified in details to ban this kind of assemblies. And also we can say that there is some move from the authorities, because sometimes they don't want to engage in these controversial issues, and therefore the courts are invited to assess some such restrictions.
Thank you.
Yeah, this is also a very interesting situation connected with assemblies at the houses of politicians. Formally, it is allowed to protest around the houses of politicians. For example, General Jaruzelski, who introduced martial law, so they were every year to commemorate the December of 1981. And also before the Prime Minister Donald Tusk, finally it was allowed such demonstration by a court. What is important here, that it is allowed, in contrast with Hungary, that is not allowed, and it is combined in the constitution that assembly may be restricted because of the privacy. Yes, privacy, and yes, these rights of other people, and it is also, it was provided because of Viktor Orban. Yes, so because he doesn't want to have protesters before his home. What is important also, that during the peace government, the house of party leader Jarosław Kaczyński was extensively protected. You can see here this picture show you how police
was protected the whole district during the mass protests in the streets. So they were concentrating on the house of the leader of the party, ruling party.
Nobody could enter this area, even it was not banned. Yes, so the assembly could be organized, but the police protected the area.
Okay, so I think that we've about some
Simultaneously,
something.
yeah.
There's always the question of assemblies during the states of emergency. Of course, that was the question: should it be allowed during the COVID, for example? And the different countries they went different ways, and it was totally prohibited in Poland, so that was very restricted. We had also the ban on assemblies, generally on freedom of movement during the crisis, migration crisis, which is still have at the eastern border, Polish-Belarusian border. So
For COVID-19, it is problematic because it was total ban on that. And it was provided not in the statute, but in the governmental regulations. So some courts, Supreme Courts and the Supreme Administrative Court decided that it is not constitutional. And here you can also see the
biggest protest of the last years, I think.
Yes, last years, but connected with the Constitutional Tribunal decision to restrict abortion law. And during the COVID-19, when there was a ban on organizing assemblies, even though women, and not only women, but many people protested because of this decision.
And it went to such a mass scale that it was unable to control by the government.
Yeah, but they were also violently fought by the police.
Some challenges of the recent year, for example, is the possibility of the counter demonstration, how to protect the rights of those who are demonstrating against the demonstration, for example, and we had some situations where, for example, just police tried to detain people who are trying to take part on counter demonstrations, and it was also during this former peace ruling period. For today, I would say that what we have to deal is the limits of the protest. So balancing legally protected interests, especially when you have, for example, the huge farmers protest, which block the whole squares in the cities, and of course they are restricted in this way the freedom of movement. How this protected goods could be balanced, so it's not so easy. And of course also climate activists, when they, for example, try to stop, I don't know, the movement at the airports and things like that to make it feel it to the society. So this is this question, and we would like to leave you with the final question. Are the law on assemblies and its application essential elements of the democracy? Generally, of course, we can say yes, because the issue of assembly remains one of the most important indicators of the quality of the democracy. Think tank like Freedom House, for example, includes it into its reports, and we have here the study of 2024, and freedom of assembly in Poland was evaluated for 3 points of 4 possible, with some remarks to this freedom. And I think that it could be our invitation for the discussion. So thank you very much for your attendance, for your attention for so many minutes. Thank you very much.